Hi, welcome to valuationpodcast.com, a podcast and video series about all things related to business and valuation. My name is Melissa Gragg, and I provide online divorce mediation and valuation services based in St. Louis, Missouri. Today, we're going to discuss the marital balance sheet, trusts, and divorce with Bob Boyd and Tish McDonald from Atlanta, Georgia. Bob is a co-founder of Boyd, Collar, Nolen, Tuggle, and Roddenbery, and a leader in family law who has received recognition from his colleagues across Georgia and the nation for his work in high net worth divorce litigation and contested custody cases. Tish McDonald is a partner in the trial and global practice group at King Spalding. She focuses on complex commercial litigation with an emphasis in trust and estate litigation. She also gets involved with litigation for nonprofits, real estate, and government entities. When we're looking at this, and maybe we should shoot it back to Bob, but Tish mentioned one type of trust, but are there other types of trust that we're seeing more often in divorce? Because everybody who looks at the trust has to start with those documents. There isn't any easy way to go about, even in this podcast, of like certain trusts are clearly over here and clearly over there. But do we see any types of trust consistently in divorce that maybe there are a little bit more guidance that we could provide?
Let me give just an overview on that, and then Tish can drill down on the specifics of what we typically see. So here's the common scenario, and it happens in any number of ways. During the marriage, a trust gets established, and I have to say it's sort of like that. A trust gets established for any number of reasons. Many of times, it's for good reasons. It's typically done to do estate planning and protect the marital estate from taxes. Okay, perfectly valid reason. And I don't mean to be emphasizing gender here, but I'm just going to talk about husbands and wives. Let's just say that the husband goes to the wife and says, let's set up a trust so we can beat the government out of some taxes. And what typically happens is he sets up the trust. The wife, and that's an important term Tish is going to talk about in a minute, becomes the beneficiary of the trust. Sometimes the kids are also beneficiaries of the trust. It's all well and good until one day somebody walks in and says, I hate your guts and I'm divorcing you. Then what do you do? How do you unravel a trust when it's an irrevocable trust? That's a typical situation we see. The other one that we see is where marital property gets put into a trust in the same form and fashion I'm talking about, and one of the spouses doesn't know about it. It's done without their knowledge. So, Tish, do you want to talk about those self-settled trust and
yes,
carve-outs?
Yes, and in fact, just to give a little bit more definition on what Bob's describing about self-settled trust, that is when, and again, I'm repeating some of what Bob said, but a little bit more definition, is when a divorcing spouse sets up an irrevocable trust and names himself or herself as part of a class of beneficiaries, okay, and is the trustee, okay? Bob did not have that in his particular example. That is commonly known as a self-settled trust. The assets of those trusts are usually not off limits, frankly, if it's funded with what would be marital property in the event of a divorce. And the reason why is there's been not to get too technical, but there's been a merger of legal title, which is what the trustee has, with beneficial title, which is what the beneficiary has. If they're the same person, in some respects, what that spouse gets when he or she set up the trust could be subject to claims from the other spouse. I will tell you, Bob, and I will. He and I are both dealing with sort of a new phenomenon, and that is what we call dealing with the trusts that are set up in what we call domestic asset protection trust states. And that's where self-settled trusts are A-OK, and you can be protected if you are a spouse who's a commonly termed a debtor, and you create a trust in one of these states. It's going to be a good argument, at least in those states, that the assets are off limits from creditors. And there are 19 such states. Alaska was the first in 1997. And Nevada is one where it's very, very pro debtor state. So that's what we're seeing more because, for example, Bob and I are both in Georgia. One question is, will Georgia, which is not one of those states, honor a self-settled asset protection trust that has been set up in a state, which would be perfectly legal there? Bob, do you agree?
Nobody litigated that in our state, and I don't think we know of anybody that's actually litigated that question. Have we, Tish?
We do not.
Right.
We do not. And in fact, Georgia,
because I mean, wealthy people set up these self-settled trusts all the time.
right?
And it's in the times that we've had them in cases, the cases have always settled, and it's not had to go in front of a judge and rule what happens to the property. But someday it's going to happen.